So we will start with Mr. Roth.
Commission, my name is Shane Roth. You have my original complaint and supporting documents, and although I just saw your motion, I ask that the pre-hearing memorandum of facts and law with attached exhibits be officially entered into the record. You need a copy of it.
So entered.
Thank you.
And I have a question.
Yes.
That's your original
Oh, no, this
complaint?
is the pre-hearing memorandum that was submitted on April 7th.
Do we accept all of that? Oh,
Okay,
okay.
it's fine.
Okay.
I'm not going to refer to it in the hearing,
Okay.
but I have asked
Okay.
it to be entered into the record.
Okay, that's fine.
But I'm not going to refer to that.
Okay.
I'll stick with the... This is a complaint about the conduct of a custodian of a public office. And members of the commission, your decision on this complaint will affirm the conduct of every person who will serve as future custodians of the office that Mr. Nelson currently holds. None of the members of this commission know what the intent of Mr. Nelson's successor will be, or the intent of the next 5 citizens who will serve in the office that is in Mr. Nelson's custody today. Intent is not an appropriate factor in deciding whether or not Mr. Nelson's conduct is an ethical violation. It's the conduct itself, as documented in the record, that's an ethical violation. This isn't a judgment about whether or not Mr. Nelson's a bad guy. This is a judgment of what conduct is appropriate for any custodian of a seat on the county council. My burden is to prove by a preponderance of the evidence that Mr. Nelson engaged in conduct that was in violation of the Whatcom County Code of Ethics, and I am prepared to meet that burden now. Leading up to the council meeting on December 8th, 2009, 24 Whatcom County citizens applied to be nominated for the council seat that was vacated by Bob Kelly just 2 weeks before. Each member of that group of 24 citizens had a direct financial interest in the outcome of the appointment process. At the meeting itself, before any vote was taken to appoint any nominees, Mr. Nelson was nominated to fill that seat. The moment Mr. Nelson accepted the nomination, he joined that group of nominees. He became the 25th nominee with a direct financial interest in the outcome. But Mr. Nelson had 2 things that the other 24 nominees didn't have. He had the ability to vote on the matter and a statutory obligation not to use that ability. According to the governing principle of the Whatcom County Code of Ethics, described in Whatcom County Code 2.104.20, a county council member with a private interest in a matter shall not vote on it. Council members are the only elected county officials held to this standard, by name. The key characteristic of a private interest, as defined in the Whatcom County Code of Ethics, is a direct financial gain or a direct financial loss. Since the appointed nominee would get a council member's salary and benefits worth about $20,000 altogether, give or take, naturally, there was a direct financial gain to be had. However, not all direct financial gains or losses are private interests, and the Whatcom County Code allows for this. If the loss or gain to a council member was no greater than to any other member of the group affected by the policy or law, then the interest would be mutual. It would be a shared interest, a collective interest. Like if all members of council voted for a pay raise, they would all be interested equally. But on the matter of the vacant county seat, this was a zero-sum gain. An equal gain wasn't possible for anyone in this group. The financial gain was going to only one nominee. For Mr. Nelson, this financial gain was clearly a private interest. The record clearly shows that Mr. Nelson became a nominee and then participated in a series of votes that had a direct bearing on which nominee might be appointed. Mr. Nelson had a statutory obligation to abstain from voting on this matter entirely once he accepted the nomination. He voted anyway, and he violated the governing principle on which the entire Whatcom County Code of Ethics rests. The Code of Ethics also prohibits county officials from using their office to secure special privileges. This is from Whatcom County Code 2.104.43 Part A. The section is titled Prohibited Acts. My original complaint and the facts I've entered into the record today also refer to a Washington state law describing the same prohibition. It's got the same title too, Prohibited Acts. The Code of Ethics doesn't define a special privilege, but I found a definition from Black's Law Dictionary, 7th edition. A privilege granted to a person or class of persons to the exclusion of others and in the derogation of the common right. Now, I was doing fine right up to the part about derogation of the common right, so I went back to the dictionary. And it turns out that derogation means the partial taking away of the effectiveness of a law. Bending a rule. A little bit or a lot, but it's bending a rule. The key feature of a special privilege is that it's exclusive and it kind of bends the rules a bit. Mr. Nelson secured special privilege, well, one special privilege I'm going to talk about in my original complaint. Mr. Nelson was the only nominee who had the ability to vote on who might be appointed to the vacancy, as I mentioned earlier. Once Mr. Nelson became a nominee, his ability to vote on the outcome became a special privilege compared to the other nominees, the other members of the group. When compared to the inability to vote at all, the ability to cast even a single vote is about as special as a privilege gets. Since the only way that Mr. Nelson could exercise this special privilege was by direct use of his office, this special privilege is clearly a prohibited act as described in the Washington County Code. Every vote that he cast was a statutorily prohibited act. The record clearly documents that he engaged in this conduct. Mr. Nelson acted and violated the Code of Ethics. I read Mr. Nelson's original response, and it speaks to intent, it speaks to conscience, it speaks to a strong personal sense of responsibility, a desire to prevent his constituencies from being disenfranchised, a firm personal sense of duty. Mr. Nelson, in his response, described his frame of mind for the commission, and he did so in terms that I hope the commission will agree speak very well of Mr. Nelson's character and demonstrate that Mr. Nelson takes seriously his role as a public servant. The response provided great insight to the commission about what Mr. Nelson was thinking, feeling, when he took the actions documented in my complaint. But this complaint has nothing to do with Mr. Nelson's motives or intentions or conscience. The only information that is germane to the complaint itself are the facts in the record as I presented them to you, and the law, which you have demonstrated you clearly understand. Mr. Nelson's actions, as documented in the record, either constitute a violation of the County Code of Ethics or they don't. Intent, motive, and conscience don't enter into it. The record documents Mr. Nelson's conduct in office. The conduct itself is a per se violation of the Code of Ethics. My burden is to prove by a preponderance of the evidence that this conduct occurred and that the conduct violated the Code of Ethics. Nowhere in the complaint procedures of this code is there any mention of me having to prove intent or any other more complex aspect of anything. The conduct is in the record. The record is now in your hands. I've met my burden, and I yield the floor to the chair.